Leases. For most of you, your leases are going to be your second largest expenses after employees. Okay? Leases are very problematic because leases often have this, well, if you don't notify me within 180 days, then we're going to renew automatically for a 5-year period at a new rent, which is the fair rental value of the property. I love that. Fair rental value of the property. Now, that's one of those lovely litigated terms. Everybody needs to be very cognizant of what their lease terms are. Sometimes you might have gotten some free rent up front, but in return for that, they jacked up what your rentals are going to be on the back end. Sometimes you might think that you have a right of refusal over your building, which is because you said, hey, if I want to expand, I want to have a right of refusal. And you might have talked about it in the negotiation phase, but it may never have actually made its way into the lease. So you may not have the right to take over that new space that opened up next door because you didn't actually put it into your lease at all. The leases are imposing. They tend to be, 60-odd pages long. A lot of them, they still like to use legal paper. It's the only thing I ever see legal size paper used for anymore are leases. And they're written worse than tax laws are. I don't know what to say. But you need to be aware of what they are because if you want to get bank financing, they're going to be looking at your lease to see what your lease terms are. If you want to be able to expand, you need to look at your lease. If you want to be able to contract your space, you need to understand what it is that your lease allows. If you want to be able to do some cost forecasting going forward, you need to understand that, hey, in year 11, I agreed to an 8% hike of what my rental payments are. And a lot of times you do that because they gave you free rent on the front end. So this is an area where, again, I see businesses starting to falter because they had an expectation of this is what it was, or they had a memory of this is what my lease said, and the reality of the lease is something entirely different, and you don't have the negotiation room to really deal with it. Maybe you don't want to move, maybe you do want to move, whatever it is, but this as your second largest expense is something that I just encourage you, one rainy weekend, just pull it out and read the thing and make sure that you actually understand what it says. Highlight the important things. Here are the payment, here are the termination. Put the date on your calendar that you have to notify them by if you don't want to be able to keep the lease. Things along those lines is where I see that business owners sort of get into some trouble with stuff. Employment agreements. We talked about having employees versus independent contractors. So now that you have said employee, what happens when you're happy with them and what happens when you're not so happy with them, okay? New Jersey is what we call an at-will employment state, which means that anybody can quit for any reason, that you can fire anybody for any reason, so long as that reason isn't discriminatory, okay? So let me give you an example. Somebody comes in and they're wearing, Chris left, but they're wearing a Rangers cap and you're a Flyers fan, okay? And he keeps wearing the Rangers hat and you really hate the Rangers hat, you can fire him because you don't like the Rangers hat. However, if he comes in wearing a yarmulke and you don't like the yarmulke, you can't fire him for doing that because that's discriminatory, okay?
Rangers yarmulke.
So, I have never seen a Rangers yarmulke, so potentially that would be, it depends on how much of a Flyers fan you are, okay? So,
It's the Rangers house here.
I understand. It's okay. So it could go the other way. So just try, but you're going to remember the example here because I just trot on your team. See how that happens? So, yeah, Kathy, you have a question?
I do. I have a situation where I'm considering letting somebody go.
Right.
Primarily, and I guess the situation is we have a number of staff, and I have other folks that can do the same job but get paid less.
Sure.
Is that a legitimate reason?
Yes.
Okay.
But it's not a legitimate reason because the
And
person...
there is some other considerations,
And you know what? And there always are, okay? I mean...
so discriminatory where they may raise it as a discrimination.
That's okay. We're women. We could say that you fired us because you don't like girls, you mean, you don't like tall people, you like people with red hair, whatever it is. There are only certain categories of discrimination: race, religion, gender, sexual orientation, things such as those. Like you might have heard that you can't ask somebody if they have a family when you're interviewing them. You can ask them if they have kids. You just can't base your hiring decision on whether or not they have kids, if that makes sense. So the better practice is not to ask so that you never get into the issue at all. You can fire anybody for any reason as long as it's not discriminatory. But what you're asking about, and this is what you really fear, is, well, is the person going to then come back and claim against me, okay? Well, let's say I say yes, they're going to file a claim against you. Guess what? You can't do anything about it, okay? You can have a properly documented employment agreement. You can have an employee manual. You could have done annual reviews like you're supposed to and have a file on them. that none of that's going to stop them for pursuing you for a claim of unlawful dismissal, however. Okay, but the standard that I think is higher than most people think that it is. It's usually what ends up happening is you get a call from the unemployment benefits office. You're dealing with like an unemployment claim. What does happen with a cranky employee sometimes, though, is they were a cranky independent contractor because you weren't paying them as an employee, and then they actually call the state and say, well, they should have been doing this, and that's where a lot of the audits come from, are from dismissed independent contractors that should have been employees. But you can get rid of people for whatever reason. But in order to have those standards, it's the same way, like I said at the beginning. What's your exit strategy? Plan for your exit strategy with your employees. What's your exit strategy for your employees? Start with an employment agreement. The employment agreement that says, here's what your job description is. Here's what our hours are. Here's what my expectations are of you as an employee. Here's the methodology by which you are going to get paid. Here is what our individual rules of the road are, so that when somebody isn't meeting those rules of the road, you never have an issue when you have an employment agreement that they didn't know what the expectations are. Because even with an employee handbook and they signed off on it, it's however many pages long. If you have an employment agreement, it's very clear because it's their employment agreement. This is what my expectations were of you. And then when you do their reviews every year, you say, we modify. I find your position changed. We both sign off that your position changed. Here are my new expectations for you. Because what you want to do in terminating somebody is be able to prove that you're objective. That's if you need to defend a case. And if you can say, here were the 8 things that I asked you to do. Here were the 7 of them that you seemed incapable of doing. Here's the period of time over which we talked about doing these 7 things, and it's just not working for me anymore. And that's sort of, somebody for cause. Other times it's just that we don't have the position anymore because we're reorganizing the department and the skills that you have no longer match what it is that we're doing. And while there is an issue of, being careful with terminating people, when you have those, you may want to reach out to a labor law attorney. Like if you have a real specific issue that, look, this person is really going to be a problem to do that. But what I would counsel you to do is if you're spending this much of your very valuable time and energy on dealing with somebody who is an unproductive employee, find a way to get rid of them. Find a way, whatever it is, to say, I'm done with this, and whatever the consequences are, you keeping them on for another 11 months of misery isn't going to modify what the consequences are. So, you have a question?
Yeah, you may not have seen this, and I guess that's what my question is, being a tax attorney, it's a little different. I sell employment practices liability insurance.
Very good thing to have.
I've never, thankfully, had a claim, so I don't know how it works.
It's usually like sexual harassment kind of claims,
No,
things
I
like that. Yeah.
policy.
Oh yeah. No.
Does it ever come into
They they happen. So yes, and they do happen. So that you have some kind of claim, and it goes both ways. Sometimes you have somebody who's in a harassing environment. Other times you have, what do I call them? A serial harassee that goes from place of employment to place of employment and is harassed at each place they happen to be at. You know what I mean? And as an employer, you need to have it because if I make the very positive assumption that you are not a harassing type of work environment, you can always hire a serial harassee and not know it through the interview process. And now, what is it that you do, how is it that you deal with this person? Hopefully, no one's a harassing person. Back there, you have a question.
We do a 1-day pre-hire trial period.
Okay.
With my group, something that we thought of and it works well. What risk am I taking there? Or, for instance,
are you paying them for the 1 day?
Yes, we'll
Okay.
pay them for the 1 day. We have a set rate for the 1 day. They know that before they come in.
Okay.
They have the choice not to take that option. Yesterday, for instance, I had a gentleman on the job for 7 hours, and I fired him after 7 hours of the
Right.
job because he was terrible. Paid him the money that we agreed upon.
I don't know if you've hired him yet. I mean, honestly, I would actually speak to labor law counsel on that because the labor law rules are very, what I'm going to call, illogical. They are what they are. When you know what they are, you can not run afoul of them, but they aren't something where instinctively you say, okay, that makes sense. For example, in some states you can do these 80-10 work weeks that you work 80 hours over 10 days or something like that. We can't do that in New Jersey because New Jersey has a set 40-hour work week. So if you work 41 hours in any week, that 1 hour is overtime, even if you worked 38 hours in the following week. So since each state has different rules, and I'm honestly not sure with that if you've made him an employee or not in your example. I think it would be worthwhile to speak to somebody about that practice. So.
I was told at one point that it's best, caregivers they come to.
I know.
So, if there's ever a problem, we haven't had a real significant problem with anybody yet, but there's been a couple where, we kind of weed away, we don't give them any work.
Okay.
And they eventually go away.
Okay.
They do, they
That works.
They do work, yeah. So, is that okay?
Well, in your case, you're saying they're contractors, because usually what happens is they're working for 12 other agencies. They are employees. Because a lot of times they're working for other
They
agencies.
often work for multiple.
Yeah. So, if you're not giving them any work, you're not giving them, you get paid for the hours that you work.
Right.
It may not, or the hours that at least you show up and sometimes don't work, but that's a whole different story, so.
I don't know if it's legal to ask a prospective employee about their litigation history.
You can ask them, but depending on what their protected status might be, you can't use it to base your hiring decision on them. So now if you didn't hire them and you did ask, you could potentially get yourself into trouble. You can ask them for their Facebook password. You guys have all read about that. You can ask them anyway. It's the making the hiring or the termination or the compensation decision based on the information that's problematic. So if you don't ask the question, you can't really get yourself into trouble.
Yeah. Gray area though,
Huh?
with the whole kids
Of course,
thing? Come on.
well, it is. Honestly, okay, if I look at somebody and I'm like, all right, so you graduated, I'm going to take myself for example. You graduated from college in 1992, you graduated from law school in 1995, you know what I mean? You live in Randolph, New Jersey, which is a very suburban area, I'm going to make an educated guess, you're married, that you probably have kids, it's not, it's the making the hiring decision on it, that's what the problem
A
is.
lot of times people will volunteer at any interview themselves.
Yeah, well, because especially a lot of times they're like, look, I have kids. I can only work till 3 o'clock on Tuesdays and Thursdays. Is that an issue? But it's again, it's not having the knowledge. It's how you act on the knowledge. And the better part of valor generally tends to be, if I don't ask the question, I can't really get into trouble. But again, just with the employees, I think that the key thing is that you're having a problematic employee. They're taking a lot of your time, effort, and energy. Even though there's a fear of what are they going to do down the road, find a way to end it, okay? And the best way to end it, honestly, say, look, Kathy, we're gonna have to have a parting of the ways. We're just, it really hasn't been working out, but you've been working for us for, 10 years now, and we really appreciate it. So what we'd like to do is give you a week's paycheck for every year that you've been here. So that's gonna be $8,000, whatever it is. And, I have this release I have to have you sign. Now, on the releases for a termination, they're very specific. A person has to have 21 days to review them. There's some very specific law on them. But once you have that release signed, you're golden and you're done, and you can now focus all your energy on something else. And generally speaking, if you pay your problem, even if it's a serial harassee, the appropriate amount of money, they tend to take it and go somewhere else. That's just the reality of the situation. So I just want to flip over to sort of the next couple of points that I have on here. This one's very important. Non-disclosure agreements, confidentiality agreements, all right? Any company's biggest asset is its intellectual property. It may reside in your employees. You say your employees are your biggest asset, but any company's biggest asset is what have we taught our employees? What is it that we do that is different, okay? And this comes up in 4 separate areas to look at. One of which is to say to your employees, we have a confidentiality. Anything that is our confidential knowledge that nobody outside the company knows about, you can't tell anybody outside the company. And that's something that should be in the employment agreement. So, particularly, you've got a lot of processes that you do that are very scientific and very specific as to what it is that you do. So you want to make sure that that knowledge belongs to the company. It doesn't belong. Now, the person has learned something. They can take it with them, but they can't be going and telling a competitor about it. You can't, you don't erase people when they leave your employment, okay? Non-disclosure agreement. So if I say I'm going to keep it confidential, a non-disclosure agreement is usually a little bit broader because that's not always just with employees, but a lot of times you have a contract with somebody. You're going to put a non-disclosure agreement into it because it might be that, I don't want you telling other people what my payment terms are with you because I may have negotiated a deal with you because you're doing it for 3 years or because I think you're a door opener or whatever it is that I don't want you to be telling anybody else about. Or I don't want you to be sharing my methodology with somebody else. So I may have produced something and I don't want you showing it to somebody else. Because you want other people to have to come to you to buy it from you. We're all in business, right? You want people to pay you to do things. So having a non-disclosure agreement, and a lot of times that would be with vendors and with clients as well. Non-solicitation agreement. This goes into two areas. One is for customers and one is for employees. Okay? A non-solicitation is that you are agreeing for a period of time, it has to be a reasonable period of time, that you are not going to solicit, to go after, to try to do business with either what are, because sometimes our clients or sometimes it's what our employees are. Okay? And by saying you're not going to solicit our clients, let's say you have a salesman who's leaving. Okay? Guess who's been working with it? And he's going to go work for one of your competitors, of course, right? Well, guess who's been working with all your clients? The salesman been working with all your clients, okay? So even though you have the confidentiality agreement and you have the non-disclosure, for the salesman to look good at his new position, he's going to want to go and get as many new clients as he can right away. Well, who does he know? Your clients, okay? So you want to have in there it's not a non-compete. Because you say non-compete, like, oh, I can't work in my business. This is my field. How can I not compete with you? So you're not even saying as much as a non-compete, which is broader. A non-compete is saying, I make widgets, you can't sell widgets, okay? A non-solicitation is saying, you can't sell anything to my widget customers. So it's a narrower thing to be able to do. But you want to have this in all of your employment agreements, that they're not going to go and solicit your customers for anything. Even if they just came up with like a new facial product, you don't want them pulling up your customer list as the basis for what their next business enterprise is going to be. The other is non-solicitation of employees. Because now the employees do have all this knowledge, they are a great asset to you. And depending on what field that you're in, we see a lot of rating going on, okay? So one employee leaves, all right? You know, you'll get $500 for every one of your friends you can get to come over here, right? Well, guess what they do? They start calling everybody else, and they're still in the honeymoon phase of the new job, you know, where everything's great, nothing sucks yet. And, you know, so, and then they go, oh, well, come over here and come over here. And all of a sudden, you're down 7 employees. And this is a huge problem for you. So you also have in the employment agreement and any agreements that you have with your clients that they cannot solicit your employees. Because other times, sometimes clients will look at your bill, be like, all right, but Bob's the one that always comes out here and does it. A lot cheaper for me just to hire Bob. All right, so if he now goes and hires Bob, now you don't have Bob to work on any of your other clients. Now, but if the client comes to you and says, I'd like to be able to hire Bob, you may say, well, that's great, but then we'd like to have a 2-year guaranteed contract in return or something like that. Because the only reason Bob's so great is because you trained him. So otherwise, Bob wouldn't know anything. So to have these, to be looking at how do I protect my intellectual capital that I have. And when I say intellectual capital, it's not your copyrights and your patents and your trademarks. It's the knowledge that you have around your business that you're by necessity sharing with your clients and your employees. Yes?
What if you have, like, when I have technicians that go,
Right.
now they go to work for a competitor.
Right.
They're not directly soliciting my clients, but they tell their sales team they then go to solicit.
No, but they're indirectly, because we always say directly and indirectly in any manner whatsoever, blah, 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 to cover the whole world. And the issue is with them because you can't go after the third party. He went to go work for Acme. You can't go after Acme, but you have the right to get an injunction to prevent him from working at Acme from doing it. So now he can't work. So look, you don't want these things to necessarily happen, but can anyone here afford to have their entire customer list scooped? I can't. You know, so you need to be able to protect what it is that you've worked so hard to create over time. Yeah.
But unless they physically print something and you can prove it, it's very difficult to prove, isn't it?
Not necessarily, because a lot of times, how else would they know the customer? Like my assistant, for example, you know, there's no way she would know who Chris Lipper was unless for the fact that she worked for me. So if she now goes to sell him hair products, I have no idea what it is. She had to have pulled it out of my thing because she has no other connection with him. But I'm just picking something, so. Yeah.
Yeah, Deirdre. I hired somebody who I didn't know had a confidentiality agreement. And we did get inquiries from a client of which the old employer complained
Right.
that was solicited. It actually wasn't solicited. But what's my liability as hiring the...
You don't have the liability unless you knew about it and were doing it to like steal your competitor's information. But the problem that you have is you may have put all this time, effort, and energy into training somebody who is now an immediate liability to you, and you're not going to keep them at all. So one of the things that we always have in our employment agreements is you always put in that you are not currently subject to any kind of non-compete, non-disclosure, or anything else agreement, so that you're aware of it up front. Because it could be that you look at the agreement and you're like, you know what, I can live with this because I'm going to train you to work in this other area, so it's a non-issue. Or you could look at it and say, you know what, I'm sorry, this doesn't work for me at all, you're not going to be able to work here. But you want to know that before you hire them, not afterwards.